Order, order. I would like to remind members to send their speaking notes by email to hansardnotes@parliament.uk and to ensure that all electronic devices are switched to silent and to remind that tea and coffee are not allowed during sittings. Can I also just remind members, it's going to be a busy morning. Please do speak through the chair as usual. Refrain from you unless you wish to speak to me. And we will move on at haste. We now come to new clause 1. I call Sian Berry to move new clause 1.
Thank you very much, Chair. It's a pleasure to speak under your chairship today again. I rise to speak to new clause 1, which I've tabled as a probing amendment. In short, this would bring the test for recovery of universal credit overpayments caused by official error into line with Regulation 100(2) of the Housing Benefit Regulations 2006. This would mean they can only be recovered where the claimant could reasonably have been expected to realise that there was an overpayment. To provide some background about why the amendment is needed, in 23 to 24, according to DWP data, the best part of 700,000 of the new universal credit official error overpayment debts entered into DWP's debt manager system were caused not by fraud or claimant error, but by government mistakes. Unlike many other benefits, DWP can recover official error universal credit overpayments from claimants. This power was introduced through the Welfare Reform Act 2012, representing a significant change to the position that had previously applied to most legacy benefits. When concerns were raised at the time, assurances were provided by the then Minister for Employment that the DWP do not have to recover money from people where official error has been made, and they said, we do not intend in many cases to recover money where official error has been made. However, research by the Public Law Project shows the DWP's default approach is to recover all official error overpayments. Relief is dependent on individuals navigating a difficult and inaccessible process to request waiver. In 2022, only 26 waiver requests were granted. These DWP mistakes matter. The financial and psychological impact of overpayment debt recovery on individual claimants can be severe. The research I have mentioned also found that recovery of debts, including official error overpayments by deductions from universal credit, led to a third of survey respondents becoming destitute. The risk of harm is particularly acute for official error overpayments, which individuals have no way of anticipating, leading to sudden, unexpected reductions in income, impacting existing fixed commitments and carefully planned budgets. Recovery of official error overpayments brought an added sense of injustice, with individuals finding themselves in debt due to a DWP error over which they had no control. For example, one claimant was overpaid universal credit due to the DWP failing to consider income from her widow's pension. She had informed the DWP that she received this and had been assured that it would not affect her claim. She relied on that assurance and spent the money on daily living expenses. 4 years later, the DWP told her that they would be recovering the resulting overpayment of £7,258.08. Aside from the significant financial impact, the stress associated with recovery impacted her mental health. She found herself constantly thinking about the overpayment and how she would pay it back, which in turn impacted on her physical health. She was left anxious that mistakes would be made again, leading to her incurring debt she had no power to avoid. Recovery often puts individuals who've relied in good faith on these payments in financially precarious situations, forcing them to make difficult choices about sacrificing essentials. Research by the Joseph Rowntree Foundation has found that the current standard universal credit allowance is not sufficient to cover the cost of essentials. In this already difficult context, households repaying overpayment debt can lose up to 25% of their standard allowance each month. People often base key life decisions on financial planning on information provided by DWP officials about their entitlement to universal credit. An official error universal credit overpayment can also have a knock-on effect on entitlement to other support, such as council tax reduction. I'm sure the DWP does not want to be responsible for pushing someone into further financial hardship, and we can prevent this harm occurring in the first place with my proposed amendment, which would mean overpayments can only be recovered where the claimant could reasonably have been expected to realise that they had been overpaid. This is equivalent to an amendment proposed by members of the Labour frontbench during the passage of the Welfare Reform Bill. With this amendment, DWP officials would themselves consider the fairness of recovering an official error overpayment before any recovery was initiated. Increasing protections against the recovery of these overpayments would also create a strong incentive for reducing the rate of DWP errors in the first instance, contributing to a more accurate and better functioning welfare system from the outset. This bill provides an opportunity for the government to proactively address a harmful and unfair process affecting hundreds of thousands of claimants each year, easing the financial burden of debt on claimants who have done nothing wrong, and encouraging the DWP to get payments right the first time. I hope the Minister can respond to the points I've raised in relation to NC1 and sincerely hope that we will make progress on this issue as the bill progresses.
Overpayments made as a result of official error.
The question is that new clause 1 be read a second time. Rebecca Smith.
Thank you, Mr. Weston. It's a pleasure to serve under your chairmanship, and forgive me, it's the first time I've done a new clause in one of these committees. So, new clause 1, tabled by the Honourable Lady for Brighton Pavilion, would amend the legislation so that where universal credit overpayments have been caused by official error, they can only be recovered where the claimant could reasonably have been expected to realise that there was an overpayment. I'd be interested to know how the claimant could reasonably be expected to realise that the amount they had received was an overpayment, as this is the test for whether that person becomes liable for repaying the amount. If payments are made to an appointee's bank account, does that appointee become liable as per this clause for spotting the overpayment? Would the amount only have to be repaid if both the person eligible for the payment and their appointee realised the overpayment? Are there figures on how much money is currently lost and also recovered due to error, and do we therefore know how much this amendment would cost the DWP? Just as underpayments in taxes are recovered by HMRC over the following months or years, even where the individual is not at fault, it is not clear why universal credit claimants should be any different. So it would help if the Minister could explain to the committee how a repayment plan will be put in place for overpayments that is manageable for the person making the payments, and how this will be assessed. We're better off instead focusing on minimising official errors in the first place. So can the Minister explain what work DWP is doing to better guard against overpayments, given that the overpayment rate for universal credit was 12.4% or 6.460 million in financial year end 2004, compared with 12.7% or 5.500 million in financial year end 2023. I would argue that we need to focus on ensuring that overpayments are not being made, but once the error has been made, and particularly because it is so costly to the taxpayer, at that point we should be trying to ensure that the money is recouped. Thank you.
Steve Darling.
Thank you, Chair. It's a pleasure to serve under your chairmanship today. I would like to be supportive of the amendment put forward by the member for Brighton Pavilions. Ministers in recent weeks have been on the record on a number of occasions describing the DWP and the benefit system as a broken system. And so it's extremely helpful that the member for Brighton Pavilions is highlighting that, the impact that this can have on people who often have chaotic and are on the edge with their lives. I've had 30 years serving the people of Torbay through elected office, and over that time I'm extremely saddened that, particularly with the cost of living crisis in recent years, the levels of destitution that I hear from people who undertake food banks and other support for those in Torbay who are in need have become worse over that 30-year period. And whether it is Scope or the Joseph Rowntree Foundation, many of these good organisations highlight to policy developers that actually the levels of benefits are really tough, and the levels of destitution in our communities are higher than they have been for many, many years. And so therefore I would welcome some thoughts from the Minister around this proposal, because sadly recovery will often drive people into destitution and, as highlighted by the member for Brighton Pavilions, into severe ill health. Thank you, Chair.
Minister.
Thank you, Mr Weston. It is a pleasure to serve under your chairship once again. Before I come to my general comments on the member for Brighton Pavilions new clause, I will attempt to respond to some of the questions that we have heard. So in terms of how we can assure ourselves that people could reasonably have known, this is an assessment that's made by our specialist investigation teams who do this day in, day out, and there is a balance of probabilities that they would apply to instances such as that. It's a process that's been in place for years. In terms of whether an appointee would be liable for an overpayment, yes, they would. How much official error? It's approximately 0.3% of all benefit payments. Around £800 million is the most recently available annual figure. In terms of how a repayment plan is agreed, and this goes to the point that the Honourable Gentleman from Torbay was making also, again, we have a specialist team that calculates this. We have a vulnerability framework should that be required. All repayment requests are done on an affordable basis. As we heard last week, the specifics around the new debt recovery power make attempts throughout the process to agree an affordable repayment plan. The limits that the bill would put in place there would be not more than 40% in the case of an ongoing deduction, and where error is there, 20%. So the recovery causing destitution point that the Honourable Gentleman also made, he will have noted that towards the end of last year, the Department announced its new fair repayment rates, reducing the amount of deduction that can be made from benefits down to 15%. And of course, as I've just outlined, there is further provision made where we are looking to take these new powers to deduct directly from bank accounts. The eligibility verification measure, returning to the point that the Honourable Lady from South West Devon made around prevention of overpayments, is intended to, in addition to helping us identify fraud, particularly in capital and people who have been abroad longer than they should be, in terms of aligning that with their eligibility for benefits. We do think that this will enable us to identify error overpayments sooner as well, and of course people are always regularly reminded to update their circumstances also. So there are a range of mechanisms in place already to assist with the identification of overpayments. We're not complacent. We know that there are too many overpayments, just as there is through official and claimant error, just as there is far too much fraud in the department. That is why we are taking many of the steps identified and outlined in this bill. Before I turn to my comments about the new clause specifically, Chair, if before I start I could just make a correction to something that I told the committee last week when I said that the minimum administrative penalty that can be offered, which receives a 4-week loss of benefit, is £65. I misspoke, and I'd like to take an opportunity to correct the record and state that that amount is £350. But turning now to new clause 1, this amendment seeks to amend existing recovery legislation to limit when overpayments of universal credit and new style benefits caused by official error could be recovered. Specifically, these official error overpayments would be recoverable only where the claimant could have been reasonably expected to realise they were not entitled to the overpayments in question at the time that they received them. This government is committed to protecting taxpayers' money and ensuring that we can recover money owed in a fair and affordable way. The debt recovery powers in the bill apply to all debts that Parliament has determined can be pursued. Section 71ZB of the Social Security Administration Act 1992, introduced in the Welfare Reform Act 2012 under the Coalition Government, made any overpayment of universal credit, new style job seekers allowance and employment and support allowance in excess of entitlement recoverable. This includes overpayments arising as a result of official error. Official error can arise for a number of different reasons. Some errors, for example, occur as a result of the flexibility of the universal credit system. Unlike the tax credit system it replaces, UC works on a monthly cycle of assessment periods. It is to be expected that on occasion, corrections or changes take place over assessment periods. The system quickly rectifies these errors in the next assessment period, and it is vital that this functionality is maintained. In these instances, the customer is not worse off, as over the course of subsequent assessment periods, they receive the correct amount on average. I think it's also helpful to explain that under existing departmental processes, customers have the right to request a mandatory reconsideration of their benefit entitlement, as well as the amount and period of any subsequent overpayment. Following this, they can appeal to the first-tier tribunal should they still disagree with the department's decision. We recognise that overpayments, however they arise, cause anxiety for our customers. Therefore, the department's policy is to recover debts as quickly and cost-effectively as possible without causing undue financial hardship to customers. DWP's overall approach to recovery balances the need to protect public funds by maintaining recovery levels while providing a compassionate service to all customers regardless of their circumstances. The department's policy is therefore to agree affordable and sustainable repayment plans. The debt recovery measures in this bill, however, are last resort powers for debtors who are no longer on benefits or in PAYE employment and are persistently evading debt recovery. These powers apply across all types of debt. Our communications to customers signpost to independent debt advice and money guidance, and we heard from the Money and Pensions Service in the evidence session about how strong the partnership working between the department and debt sector is. DWP is committed to working with anyone who is struggling to repay their debt, and customers are never made to pay more than they can afford. Where a customer feels they cannot afford the proposed rate of recovery, they are encouraged to contact the department to discuss their repayment terms. The rate of repayment can be reduced or recovery suspended for an agreed period, and the department may also consider refunding the higher deduction that has been made. The department's overpayment notifications have been updated to make sure customers are aware they can request a reduction in their repayment terms. In exceptional circumstances, the department has the discretion to waive recovery of debt in line with Treasury's managing public money guidance. In doing so, a range of factors are considered, including the circumstances in which the overpayment arose. Finally, I have listened to and take seriously the concerns that have been made. As you know, as the committee is aware, the Minister for Social Security and Disability is looking at the policy design to ensure outcomes that tackle poverty and help people to better manage their money. And I will pass the concerns raised by the Honourable Member on to him. But, Chair, having outlined the reasons against, I therefore resist new clause 1.
Sean Berry.
Thank you, Chair, once again, and thank you for comment. Thank you to the Minister. Apologies for comments that you are taking seriously. That the Minister is taking seriously the concerns I raised. I will not be pushing this amendment to a vote today, Chair, but I do hope that it will be looked at seriously in the next stages of the bill, and that we can discuss this further in the House.
Does anyone object to new clause 1 being withdrawn? So new clause 1 by leave B withdrawn. And we move on to new clause 2. We now come to new clause 2, with which it will be convenient to debate new clause 15. Who would like to move new clause 15? I call Rebecca Smith to move new clause 2.
Thank you, Mr. Weston. We have tabled new clause 2, which seeks to make it a specific offence to commit, assist or encourage others to commit fraud against a public authority. Someone who commits such an offence would be liable to imprisonment, fine or both. The offence of fraud against a public authority in this bill is a civil offence. The government argues that civil penalties offer an alternative to prosecution and help mitigate the burden on the criminal justice system by offering alternative routes for the public sector to manage fraud cases. The bill introduces a framework of civil penalties for fraud that the Minister can impose, including on behalf of other government departments, serving as an important deterrent against fraud in the public sector. However, we think it is an anomaly for public sector fraud to be a civil offence, while benefits fraud is a criminal offence. So can the Minister explain why one type of fraud is seen to be less serious than the other? We have also tabled clause 15, which I believe I can speak to you now. The purpose of this new clause is to target those on social media, and particularly TikTok and YouTube, although I'd like to say they're not exclusively just those two, who post videos showing people how they might be able to make fraudulent benefit claims. For example, how to fill out a form to claim PIP, which does not require medical evidence but does need a self-assessment form, regardless of an individual's actual symptoms. As Professor Button said in evidence to this committee, the other thing is that social media and different types of forums provide opportunities for people to discuss how to engage in dishonest behaviour. I am doing some research at the moment about online refund fraud. We've been going into forums where a wide range of individuals discuss how to defraud retailers and get refunds for stuff that they have bought online. I strongly suspect that that kind of thing is probably also going on for benefits frauds. All of those factors are making it much easier, so I think there is much more significant challenge for not just the public sector, but private sector organisations in dealing with fraud because of that, and by that I believe he means online encouragement to commit fraud. More than 3,000 individuals are signed off work every day. Advice provided by so-called sickfluencers includes using specific buzzwords in applications, providing template claims and guidance on passing questions at the interview stage to fraudulently inflate the value of claims. Now, as we know, and we've heard many times throughout the passage of this committee stage, we know that benefit fraud accounts for almost £7.4 billion, and it is in this context that the sickness benefits bill is expected to rise by over 50% more to more than £100 billion by 2029 to 2030, which is 1.5 times the defence budget. Clamping down on fraud and those who enable it should be a priority for the government, and I recognise that this bill has gone a long way to do this. We just think there's more that we could be doing. So clearly the claimant should be penalised for knowingly making a false claim, but we believe so too should the person actively encouraging people to defraud the taxpayer and providing information to enable them to do so successfully. Now, of course, we do not want to target people who are providing genuine advice and guidance to people about how the welfare system and other public authorities work. That's incredibly important. But that is very different from providing assistance and encouragement to commit fraud, which we do not believe is acceptable, and we therefore feel that this should be reflected in the bill. And we believe that if these videos are not properly tackled, they actually become more normalised, and people online may not even realise that what they are doing is fraud and illegal. So that is something that also came up during the oral evidence session. The amendment also fits in with other aspects of the government's work surrounding online safety and ensuring that young people in particular are not taken advantage of. So our new clause would send a clear message that encouraging fraud online is both unacceptable and that there are clear consequences for those who do it. So should the government choose not to support it, I would be interested to know why the Minister might not want to accept this amendment. Obviously, if they do support it, then that's fantastic. But would the government, if they can't support it today, take this idea away and consider how to amend the bill in its later stages so as to protect against this sickfluencer trend and make sure that those who help others to commit benefit fraud are held to account? Now, I know that there might be some opposition that would say that existing legislation, such as the Online Safety Act 2023 and the Fraud Act 2006, are useful enough to cover these areas. However, as we heard from Professor Button during those witness sessions, there is an open question as to whether we need to go further. And he said, do we need to create a new specific offence of, say, promoting social security fraud online? The key thing is more enforcement and disrupting forums where that kind of discussion is taking place. We believe that our clauses directly support this by making it easier to prosecute those who encourage fraud, providing clear legal grounds for enforcement and disruption. And finally, Chair, I have heard some opposition to the measures that we are proposing, arguing that it could be a challenge to determine those who are deliberately encouraging fraud and those who are merely discussing how to support vulnerable individuals, and that's something I touched on earlier. But in response to this, I think that all that would be needed is a structured investigative approach, much like we have seen throughout this bill, which looks specifically at the content, and I believe it would be easy to categorise between what are obviously step-by-step guides posted on forums that are intended to encourage people to commit this fraud, and citizens' advice, for example, who we all know provide an invaluable service to the most vulnerable in society. I don't personally believe it would be hard to work out legitimate organisations, and that in doing so it would be pretty easy to find out those who are simply seeking to defraud the system by encouraging others to do it instead. Thank you, Mr. Weston.
Offensive fraud against a public authority.
The question is that new clause 2 be read a second time. George Gore.
Thanks, Mr. Weston. It's a pleasure to serve under your chairmanship, and I very much appreciate the honourable members' intention in bringing this forward, which I think is to take seriously forward against the public sector. But the government does plan to resist this amendment because we believe that that it's already kind of covered, as you intimated, but also that it could lead to some unintended consequences that do the opposite of what the honourable member wants. As the member will set out, new clause 2 would create a new offence of fraud against a public authority. We believe this is unnecessary and as I said, could have a detrimental effect. It's unnecessary because fraud is already an offence clearly defined in clause 70 of this bill as offences under the Fraud Act 2006 and the common law offence of conspiracy to defraud. This bill uses those offences. They do not need to be written into the bill to have effect, and we've given assurances to this effect during the previous debate on this bill. Consequently, there doesn't need to be a specific fraud offence for public authorities. Assisting and encouraging fraud against a public authority, as used in the new clause, is also already an offence. The offences of encouraging or assisting set out in sections 44 to 46 of the Serious Crime Act 2007 apply to fraud offences as they do to other crimes. Again, this does not need to be written into the bill to have effect. The PSFA will be able to investigate cases where it appears someone has encouraged someone else to commit fraud. If we do discover encouragement, it would likely form part of the PSFA's investigation into a fraud case, and it's an offence that the CPS could pursue using the evidence collected. Whether action can be taken will of course depend on the facts of the case and the evidence available, and whether the necessary standard of proof can be met. But crucially, new clause 2 would reduce the maximum sentence available for Fraud Act and conspiracy offences from 10 years to 7 years for fraud against public authorities only. And
I thank the Minister for her response, but can she explain why she feels that benefit fraud ought to be a specific offence, actually with these maximum sentences under the Social Security Administration Act, that it's not appropriate for the specific offence to apply to people who deliberately defraud other public authorities?
As I've set out, because those measures are already covered and the proposal would potentially reduce criminal offences from 10 years to 7 years, and I'm sure that the honourable member would not want those who defraud the public sector to get lower offences than those who defraud the private sector.
It should be very generous giving way, but of course prosecutors do have a choice as to which charge to bring. They can still bring a charge under the common law offence, which, as the Minister says, does have a high maximum sentence, but one which is very, very rarely imposed. Or, as is already the case with benefit fraud, they could bring the offence under the specific offence that we are proposing, where the Sentencing Council would obviously develop the guidelines that specifically apply to deliberately defrauding public authorities. And would like, whilst she's of course right that the maximum sentence under this clause is in theory is lower than the theoretical maximum for the common law offence, in practice it's likely to see rather more substantial sentences imposed upon conviction.
We already have effective fraud legislation, the issue that this bill is seeking to address is that we don't currently have the resource or the powers to properly investigate that or to recover money. But the suggestions that are coming forward, we believe, would actually have the unintended consequences of reducing the seriousness of the offence in the way that I've set out. And as I was going to go on to say, it admits the option available in both the Fraud Act offences and the common law conspiracy offence for the Crown Court to impose an unlimited fine instead of or as well as a term of imprisonment. So again, weakens the response. This is contrary to the government's intention with the bill that strong action should be taken against public sector fraud. Turning to new clause 15, this amendment seeks to introduce an offence for encouraging or assisting others to commit fraud by adding subsections to sections 11A and 112 of the Social Security Administration Act 1992. Sections 11A and 112 set out two specific offences related to benefit fraud. While the intention behind this amendment is commendable, I believe that this is not needed for several reasons, similarly to those I've set out for new clause 2. Firstly, the existing legal framework already provides sufficient measures to tackle fraud of this nature. The Fraud Act 2006 and the Serious Crime Act 2007 already make it a criminal offence to encourage or assist any other offence, including when it relates to fraud. There is also existing laws that serve a similar purpose for Scotland. Those existing laws are robust and comprehensive, ensuring that individuals who provide guidance on how to commit fraud or encourage others to do so can be prosecuted effectively. Introducing additional subsections to the Social Security Administration Act 1992 would therefore be redundant and unnecessary. Secondly, the proposed amendment could potentially complicate the legal landscape by adding new subsections to sections 11A and 112. We risk creating overlapping and conflicting provisions that could lead to confusion and inefficiency in enforcement. It is essential to maintain clarity and coherence in our legal system to ensure that justice is served effectively. Moreover, the amendment would mean those convicted of a new offence would face a less punitive sentence than they would face under existing laws. For example, a conviction under this new clause related to Section 112 would carry a maximum period of custody of 3 months compared to a maximum of 10 years under the existing Fraud Act. As a result, similarly to what I set out for new clause 2, rather than strengthening our position to respond to such types of fraud, new clause 15 could result in a weakened response. In conclusion, while the intention behind new clauses 2 and 15 is well intended, neither new clauses are needed, as the existing legal framework already provides sufficient measures to address this issue, and introducing additional subsections would only complicate the legal landscape. But I very much heard the research the Honourable Member has been doing and the importance of tackling those who set up sites to try and defraud the public sector, and be more than happy to have a further meeting to discuss how we take action with it. But we believe that we can do that within these existing powers, but would welcome that further discussion. The PSFA and DWP will be concentrating on the provisions already contained within this bill that are intended to help effectively address and combat fraud through them. I therefore ask the honourable members to withdraw these amendments.
Minister. Or Rebecca Smith, sorry.
Thank you, Mr. Weston. And I've heard everything that the Minister has said. However, I think at this point I can say we would still like to push this one to a vote. Am I allowed to say that now? Yes, please. So I think both new clause 2 and new clause 15 we'd like to take to the vote anyway.
Chair, can I ask a procedure question before we go any further? I just wonder whether, and obviously it's a pleasure to serve with you, Chair. I just wonder whether we've had the presentation of this, but we haven't had any declarations of interest, and given that there are some notable Conservative Party donors facing potential fraud charges under COVID issues, I just wonder whether that should have been a declaration before we got to the change in how people in those situations might be punished.
So I understand, although I wasn't present at the time, that all declarations were made at the time of evidence being presented to the committee. So I thank him for his point of order. Minister.
Thank you, Chair. I'm just would like to understand in relation to new clause 15 how the opposition front bench consider this to make any provision that's not already included in the Fraud Act 2006 or the Serious Crime Act 2007, which already make it an offence to encourage or assist an offence including fraud. And the reason that I stress that is that I am particularly concerned about sickfluences, the like of which the Honourable Lady set out. But I fail to see how new Clause 15 offers any provision not contained with that already, not least because it doesn't mention at any point that this would extend powers to online, presumably because, and you know, I can say actually because, online sickfluences would already be covered by this. So I understand the intent. We have a problem with sickfluences that we need to deal with, but I would be incredibly appreciative to understand how this amendment offers anything that is not already set out in existing legislation.
Rebecca.
Yeah, great. I thank the Minister for his comments, and I've obviously heard what both Minister Gould and Mr Weston have said in response to this. I think we're still keen from a principle perspective to push it to a vote anyway, because we think that there does need to be more done to outline specifically what we're doing on and to tackle the online aspect as well. And I do hear what he's saying. However, in this particular instance, I think this is to take it further from me. Thank you.
The question is that new clause 2 be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division. Lock the doors.
Division 11.
Joanna Baxter.
No.
Sean Berry.
No.
Neil Coyle.
No.
Steve Darling.
Abstain.
Charlie Dewhurst.
Aye.
Damien Egan.
No.
Jill German.
No.
Georgia Gould.
No.
Sally Jameson.
No.
Gordon McKee.
No.
John Mill.
Abstain.
Michael Payne.
No.
Rebecca Smith.
Aye.
Michelle Welsh.
No.
Andrew Western.
No.
Mike Wood.
Aye.
The ayes were 3, the noes were 11. So the noes have it. The noes have it. Unlock. Order. The committee is now suspended for 4 minutes. We now come to new clause 3, which has already been debated. Who would like to move new clause 3? Do not wish to move. We move on then to new clause 5, and I call Rebecca Smith to move new clause 5.
Thank you, Chair. We've tabled new clause 5 to require the Secretary of State to publish the results of any pilot schemes run with banks to test the provisions in Chapter 1 of Part 2. We have already discussed that banks will be required to undertake ongoing monitoring work to collect the relevant information as part of the eligibility verification. The impact assessment states that 2 proof of concepts took place in 2017 with short summaries provided of each. However, given the scale of what is being asked of the banks, as well as how technology has moved on in the past 8 years, it is reasonable to assume that pilots will also be undertaken to ensure the system works properly before it is fully rolled out. So can the Minister confirm that this will be the case? In the interest of transparency, we also need to see the results of the pilots, which is why we have therefore tabled the amendment to ensure they are published within 3 months of the Act coming into force. It is regrettable that we needed to table this new clause, but as we have said several times throughout the passage of this bill, and as we have heard from witnesses to this committee, it is extremely difficult to judge how this legislation will work in practice without seeing the code of practice and understanding what will be required of the banks. As UK Finance said during the evidence sessions, much will depend on the mechanism through which banks will be required to share the information, the frequency of the information notices, whether the criteria we are required to run checks against change over time, and other factors that will influence how much capacity is required from the banking sector. So as I say, at this stage it is challenging to do a detailed assessment. It is clear that the practical implications of how to implement the bill are not clear to banks at the moment. We also discussed the consequences of getting this wrong. As UK Finance said in evidence, under the bill, banks responding to an information request or a direct deduction order would have to consider whether there is some indication of financial crime that under POCA requires them to make a suspicious activity report. We think it is simpler to remove that requirement, not least because where there is a requirement to make a suspicious activity report, there is a requirement to notify the authorities. Clearly, there is already a notification to the authorities when complying with the measure. Removing that requirement would avoid the risk that banks must consider not only how to respond to the measure, but whether they are required to treat that individual account as potentially fraudulent. The banks are well versed in dealing with fraud, but not so much with error. We need reassurance that there are clear expectations for the banks in delivering their duties under the bill, that these are compatible with existing obligations in regard to financial crime, and that the banks can resource these.
Publication of results of pilot schemes.
The question is that new clause 5 be read a second time. Minister.
Thank you, Chair. In my view, new clause 5 is quite simply not needed to demonstrate the feasibility and potential of the eligibility verification measure. As the Honourable Lady said, DWP conducted 2 proof of concepts in 2017 and 2022, and the results of these have already been published within the impact assessment for the bill. Further information on the effectiveness of the measure will of course be available following the Independent Overseer's annual review and report on the measure. On information notices specifically, no pilot schemes have or will be conducted on those, as these are an extension of existing powers, and it's on this basis, therefore, that I resist new clause 5.
Rebecca Smith.
Thank you, Chair. I'm happy to withdraw new clause 5.
So new clause 5 is withdrawn. We now come to new clause 6, which has already been debated. Would either Rebecca Smith or no? So new clause 6 is withdrawn. We now come to new clause 7. I call on Rebecca Smith to move new clause 7.
Thank you, Mr. Weston. We have tabled an amendment to require the Secretary of State to publish an annual report detailing the amount of money which has been recovered under the provisions of this Act, with the first being published within 12 months of passing the Act. The main purpose of this legislation is to crack down on both error and fraud, and we support that aim. It is therefore reasonable to ask for transparency and to understand exactly how much money has been recovered thanks to the measures in the bill. It also means that we can be sure the Act is working as it is hoped. It if it is not, then further action will need to be taken, but at least we would know and a discussion can be had instead of brushing the issue under the carpet. An annual report allows enough time that it should not be an administrative burden for the department to produce while ensuring it remains relevant and up to date. Given the large amounts of money lost to fraud and error, it is important that we are all able to hold the government to account for how effectively they are recovering this money.
Annual reporting of amounts recovered.
The question is that new clause 7 be read a second time. Minister.
Thanks, Chair. In response to the proposed new clause 7, I would first state that I share and appreciate the honourable member's concern and interest in delivering the proposed benefits from the bill, including the effective recovery of debt. This bill delivers on the manifesto commitment that this government will safeguard taxpayers' money and not tolerate fraud or waste anywhere in public services. Turning first to part 2 of the bill, I do not think that this amendment is necessary given the existing routes for external scrutiny and reporting on DWP's fraud and error activities, including the new debt recovery powers. The OBR provides independent scrutiny of the government's costings of welfare measures. The department estimates that over the next 5 years, the EVM measure will save £940 million and the debt recovery measure £565 million. These estimates have been certified by the OBR. In total, the bill is estimated to deliver benefits of £1.5 billion over the next 5 years. In the published impact assessment, DWP committed to monitoring and evaluation in Part 2 of this bill, including the new powers to recover debt, as well as the EVM measure. Whilst I understand that the member is particularly interested in the scrutiny of the money recovered under the provisions of this bill, I'd like to remind the committee that this government has committed to the biggest welfare fraud and error package in recent history. The total DWP fraud, error and debt package, with both savings from the bill and other budget measures, is worth £8.6 billion over the next 5 years. In the annual report and accounts, DWP already report on the savings made from our fraud and error activities, including savings made from detect activity across our counter fraud and targeted case review teams. In addition to this, we report on our debt recovery totals and debt stock, so I would think that the annual reports and accounts in particular would give the honourable member the information that she's interested in. The department also publishes annual statistics on the monetary value of fraud and error. These include various breakdowns by benefit and type. This is another mechanism by which we can see trends over time and ensure transparency for the public. But turning to Part 1 of the bill, the PSFA, as it is currently set up, already has a published commitment in the PSFA mandate to produce an annual report that 1. Makes transparent the levels of fraud in government and the latest fraud and error evidence base, and 2. An annual report on its performance. Recoveries will be published in the annual report. Schedule 212 of the bill also requires that as soon as reasonably practicable, after the end of each financial year, the PSFA, when set up as a statutory body, must prepare a report on the exercise of its functions during that financial year. Recoveries will be published as part of this. So, for the reasons outlined, I therefore resist the amendment.
Rebecca Smith.
By leave, new clause 7 withdrawn, Chair.
New clause 7 is then withdrawn. We now come to new clause 8. I call Rebecca Smith to move new clause 8.
Thank you, Mr Weston. The publication of an anti-fraud and error technology strategy. Our new clause 8 would require the Secretary of State within 6 months of the passing of the Act to publish an anti-fraud and error technology strategy. This must include how the government intends to use automated technologies and AI to tackle fraud, 2A, as well as safeguards to ensure human oversight of decision-making, 2B, protection of rights of appeal, 2C, and a framework for privacy and data sharing, 2D. Now, you might say, why have we tabled this? In part, it was based on the evidence that we have received. Concerns from the Public Law Project in written evidence was that the impact assessment IA for the bill, human rights memorandum and statements from the Secretary of State and Minister for Transformation at second reading state that a final decision on benefit eligibility will always involve a human agent. However, this is not reflected in the legislation itself. In response to Public Law's concerns, this clause would provide an audit of technology systems used to tackle fraud, ensuring accountability while addressing risks posed by automation in decision-making. And in a report published by the Treasury tackling fraud and corruption against government in 2023, they said public bodies can better protect themselves by sharing data and intelligence with other public bodies and working together. Therefore, we believe the Technology Strategy Clause recognises that sharing data is beneficial to stop and recover fraud, but includes additional provisions that audit its use. That strategy must include how the government intends to use automated technologies or artificial intelligence to tackle fraud and error against public bodies, what safeguards exist for human oversight of decision-making, how rights of appeal will be protected, and a framework for privacy and data sharing. Now, on the safeguards more specifically, these are to ensure that grounds for decision-making can only be reasonable if they are the result of a process in which there has been meaningful human involvement by a human of adequate expertise to scrutinise any insights or recommendations made by automated systems. They must also make clear that grounds cannot be reasonable if they are the result of an entirely automated process to ensure that any information notice issued is accompanied by a statement that sets out the reasonable grounds for suspicion that have been relied on and confirms that the conclusion has been formed on the basis of human involvement. We know that AI and technology has huge potential to improve efficiency and productivity and should be utilised where appropriate. But we also cannot rely on it yet at the exclusion of people and human judgment. The strategy that we're proposing would ensure these points are adequately considered by the department so the taxpayer is receiving value for money while safeguarding claimants through the decision-making process.
Publication of an anti-fraud and error technology strategy.
The question is that new Clause 8 be read a second time. Minister.
Thank you, Chair. And could I thank the member for bringing forward new Clause 8. So this government recognises the opportunities that AI and machine learning can provide, whilst also understanding the need to ensure that they are used safely and effectively. In January of this year, the government outlined its response to the AI Opportunities Action Plan led by Matt Clifford, which was commissioned by the Secretary of State for Science, Innovation and Technology. This plan outlined 50 recommendations for how government can leverage AI. This included recommendations to improve access to data, make better use of digital infrastructure and ensure the safe use of AI. Under the leadership of the Prime Minister and the Secretary of State for Science, Innovation and Technology, we have endorsed this plan and the government is taking forward those recommendations. As the government works to implement the recommendations in the AI Opportunities Action Plan, I do not believe a separate anti-fraud and error technology strategy put forward by this amendment is necessary. I believe this new Clause 8 would cut across the work being taken forward under the Opportunities Action Plan, so I reject the amendment. As technology advances, the use of AI and machine learning will play a crucial role in detecting and preventing fraudulent activities. The government wants to make use of technology and data to tackle fraud, as the department has a responsibility to ensure fraud is minimised so that the right payments are made to the right people. The government remains committed to building our AI capability, and at DWP we will take advantage of the opportunities AI can offer whilst ensuring it is being used appropriately and safely. Of course.
Rebecca Smith.
I thank the Minister for giving way, and sorry, I should have done this earlier on in what you were saying, or what the Minister was saying. The Minister has mentioned the government's AI strategy. This new clause here is putting this requirement on a statutory basis rather than simply a manifesto commitment basis that's not written into law. And I think the reason why that is important to us is because in the case of fraud, particularly benefits fraud, we're dealing with individual people and making sure that we don't inadvertently penalise the wrong people or apply something that is disproportionate. And I know a lot has been said about making sure that there is proportionality and reasonableness. So I would just be interested in the Minister's reflections on where else in the strategy that he's referred to, there is something that is quite so personally applied to potentially quite vulnerable groups of people that therefore would say that we don't need this protection to ensure that those we are utilising this legislation to kind of tackle the fraud that they're committing are not inadvertently penalised as a result.
Minister.
I think that's a reasonable question, and clearly the AI framework isn't specific to vulnerable groups in the way that she has set out, but decisions regarding benefit entitlement or payment within the department are made by DWP colleagues who always look at the available information before making a decision. I wouldn't want to put something into this legislation that restricted that to only the activity within this bill. I would want it to be departmental wide, as I've set out a number of times in contributions at every stage, in every area of this bill. A human is involved in decision making. There is no plan to change that. I can understand her anxiousness to see that set out in legislation, but I think it would create an anomaly between the practices within this bill and in the department more broadly. For instance, it is outside of the scope of this bill that a human completes the vulnerability framework when looking at somebody coming forward in financial need but who has an overpayment. I wouldn't want to make a distinction between these powers and the rest of the department's activity. So if we were to have a broader debate, I'd be happy to engage with her on that basis, but I wouldn't want to create, for want of a better word, a two-tier description within the department. But at every stage of model development, as we do bring forward the Opportunities Action Plan and the work that we are taking forward in the AI and tech space, we do ensure checks and balances are in place and that we have strong safeguards. I'm proud of our commitment to use AI and machine learning in a safe and effective way. To provide further assurances about our processes to Parliament and the public, we do intend to develop fairness analysis assessments which will be published alongside our annual reports and accounts. These will set out the rationale for why we judge our models to be reasonable and proportionate. This reporting commitment on our fairness analysis assessment further negates the need for this new Clause 8. Finally, the member mentioned about the role of new Clause 8 in ensuring reasonable grounds of suspicion for investigating fraud. I remind the committee that under the information gathering powers, DWP may only request information where an authorised officer considers that there are reasonable grounds to suspect a DWP offence and that it is necessary and proportionate to obtain that information. So again, a human fully baked into that process. The changes brought in the bill will be reflected in the new Code of Practice, and updated mandatory training will be provided for staff who will be accredited to use these new powers, but of course with the eligibility verification measure in particular, but running throughout the bill, the principle of independent oversight is very much in place. I hope that that will provide the Honourable Member with the necessary information to show that the Government will only use information gathering powers where there's a reasonable suspicion of fraud, and that this will have considerable human involvement. But I do agree that there is perhaps a broader conversation to have about this at an appropriate time in the future.
Rebecca Smith.
Thank you, Mr Weston. By leave, I'll withdraw new Clause 8.
Does anyone object to new Clause 8 being withdrawn? New Clause 8 is withdrawn. We now come to new Clause 9, with which it will be convenient to debate new Clause 12. I call Rebecca Smith to move new Clause 9.
Thank you, Mr Weston. Our new Clause 9 would require the Secretary of State within 6 months of the passing of this Act to lay before Parliament an assessment of the expected impact of the Act on vulnerable customers. There have been concerns expressed in the written evidence submissions regarding the impact of the bill on disabled people. It is important to ensure that vulnerable people are not inadvertently harmed by the measures of this bill. There was, for example, a discussion about vulnerable customers in the oral evidence. We heard from Daniel Chikoki and Eric Leanders, both who supported the notion of an impact assessment, but they were concerned about the mental strain of being under suspicion and referenced that the FCA is due to publish a thematic review on this imminently. They believe that this, we would suggest that this strengthens the case for a comprehensive assessment from the Secretary of State. Now, we would define vulnerable customers as meaning someone who, due to their personal circumstances, is especially susceptible to harm, particularly when a firm is not acting with appropriate levels of care as per the definition used by the Financial Conduct Authority. So it will be a familiar one for the sector. The reason that we think new Clause 9 is necessary is both because some of the people who will be impacted by this Act will be vulnerable, and in some cases will be repaying money that they did not acquire by fraud. These will be overpayments as a result of error from DWP. It is also necessary because, as we heard from UK Finance, there are duties that banks have where they suspect that financial crime is taking place. Error is obviously not financial crime by the person who holds the account into which the payments have been made, but there is a risk that this Act does not sit well with the existing duties on the banks. We need to make sure that both communication with vulnerable customers of banks is of a sufficient standard, particularly in cases where DWP is recovering funds for which the customer is not at fault, and because the group of people we are talking about is likely to have high levels of vulnerability. Now, if the Minister is not going to accept this amendment, I would be grateful if we could have an explanation of why, and importantly, how the Government intends to undertake this kind of monitoring, because we believe it is important that it happens. And if I just briefly speak to Liberal Democrat New Clause 12, which requires an independent assessment of the impact of the Act on people facing financial exclusion, I would be interested to know whether the Liberal Democrats have a particular individual or organisation in mind as being appropriate to undertake this assessment, but we do not have difficulty with the principle of the amendment as it stands. Thank you.
Impact of an Act on vulnerable customers.
The question is that new clause 9 be read a second time. Steve Darling.
Thank you. Apologies, Chair. I was rising to speak on new clause 12, so I'll leave that. I wasn't quite sure of the procedure. Yeah, so if you're happy to, I will speak on new clause 12 if that's permitted, Chair. Thank you. So new clause 12 is about financial exclusion, has already been alluded to for the member for South West Devon. Our concern is that as this morning goes on, a number of safeguards are looking at being, for want of a better phrase, baked into the system by legislation. And yet the only thing baked into the system, according to the Minister, is the involvement of human beings, which causes myself and I'm sure other colleagues concerned. By ensuring that this annual review takes place, into the impact on financial exclusion by the independent person appointed, then the Minister publishing it, sharing this with Parliament, we can ensure that there is a level of transparency. Whilst I'm sure many of us would acknowledge that those ministers in place at the moment are well-meaning individuals, who knows where we will be in 10 years' time, and this legislation needs to stand the test of time. And so baking into this these safeguards is a positive way forward, and I would hope that the Minister would welcome this way forward, and I look forward to his comments, Chairman.
Sean Berry.
Thank you, Mr. Weston. I just wanted to rise very briefly to say that I have a lot of sympathy with both of these amendments from my honourable colleagues. It is really important that we do look at very closely, and we are mandated to look closely at the impact of this Act on the people whose examples we've raised throughout the debate on this bill. So I very much think that the Minister should answer the questions being raised by the other members and say what they're going to do instead, if not the things proposed in these amendments.
Minister.
Thank you, Chair. If I begin with new clause 9 put forward by the member for South West Devon, I share her view that where the powers in this bill are exercised, there should be a consideration of the vulnerabilities that customers may have, whether these be the customers of data holders, e.g. customers of banks, or customers of government, e.g. The customers of DWP. However, I do not think this amendment is necessary given the existing safeguards, oversight and reporting provisions in the bill. The bill includes a number of protections for vulnerable people. This includes affordability considerations and protections for persons experiencing hardship, rights of review and appeal, and independent oversight. These provisions have already been debated and considered by this committee, so I won't labour the point. However, I will make a point about the provisions in the bill for independent oversight, as these will play an important role here. I remind the committee that those persons carrying out independent oversight will report on whether the government has used the correct powers appropriately and effectively in compliance with relevant codes of practice guidance, and if the exercise of those functions has been correct, effective and appropriate. This, I'm sure, will involve HMICFRS considering, for example, whether the PSFA or the DWP has given appropriate consideration to the vulnerability of customers in its fraud investigations. Furthermore, I'd remind the committee that supplementary documentation, including the explanatory notes, impact assessments and policy fact sheets that accompany this bill, all outline how further vulnerabilities will be considered in individual measures. There is a principle throughout the powers that vulnerability will always be considered as part of the assessment before any action is taken. To give some examples, this might include the consideration of vulnerabilities in the risk assessment undertaken before the use of the powers of entry, search and seizure in the bill, or the consideration that must be given to affordability and beneficial interest before any direct deductions are made from bank accounts to recover debt. The combination of robust safeguards, independent oversight and reporting mechanisms already in the bill mean that I resist new clause 9, and turning to new clause 12, I recognise the intent behind the amendment put forward by the Honourable Member for Torbay, and I appreciate his advocacy for protecting individuals from financial exclusion. This is an important point. However, I am confident that again this reporting will not be necessary. DWP and the PSFA are working closely with stakeholders from the finance industry, including the Financial Conduct Authority, to ensure that no one is inadvertently or unintentionally excluded from access to financial services. For example, in the DWP's eligibility verification measure, there is an important exemption in Schedule 3 of this bill that ensures a bank or other financial institution which complies with an eligibility verification notice is exempted, and this goes to the point made by the Honourable Lady from South West Devon, from specific disclosure obligations under the Proceeds of Crime Act 2002, namely Section 330 and 331. These exemptions apply if the information is obtained solely as a result of the eligibility verification measure. They do not exempt individuals from their ongoing duty to report knowledge or suspicions of money laundering under the Proceeds of Crime Act that might arise independently of EVM. In practice, this means that under this exemption, banks are not required to report if they have reasonable grounds of knowing or suspecting money laundering through a suspicious activity report, where that arises solely as a result of complying with a notice. Banks should not close or suspend any accounts or debank anyone solely in response to information obtained under this measure. This is because at the point a bank complies with the notices, there is no presumption of wrongdoing. We heard, as has been said from Mr Kachoki from UK Finance, that this was an important exemption, and I very much agree with him. With respect to the Public Sector Fraud Authority, they will align with the government debt policy as well as abide by the standards set out by the government debt management function and the debt management vulnerability toolkit in respect of how to consider those at potential risk of financial exclusion. PSFA also continues to engage with the financial sector to develop mitigations against financial exclusion. With these protections, I'm confident that there are necessary provisions in place for individuals to protect them from financial exclusion in this bill, and therefore do not think this reporting requirement would add additional value beyond the independent oversight and reporting already provided in this bill. Chair, I therefore also resist the proposed new clause 12.
Rebecca Smith.
By leave, Chair, will withdraw new clause 9.
Does there anyone object to new clause 9 being withdrawn? New clause 9 is withdrawn. We move on to new clause 10, with which it will be convenient to debate new clause 11 and amendment 32. I call Steve Darling to move new clause 10.
Thank you, Chair. And I would encourage colleagues to support these proposals around carers allowance. It's items that we've already discussed elsewhere during this bill, and carers are the backbone of many of our households across the United Kingdom, and I would hope for support from the Minister on this amendment that's before us today. Thank you.
Recovery of overpayments of carers allowance.
The question is that new clause 10 be read a second time. John.
Sorry, Chairman, I was looking to speak on new clause 11.
That's certainly.
No. Thank you, and it's a pleasure to serve under your chairmanship. As we know, the DWP is making extensive and growing use of algorithms for investigation purposes. Without proper oversight, these systems will risk error, unfairness and bias, which could lead to wrongful debt collection. So our amendment calls for an independent audit of these systems at least every 6 months to ensure accuracy and fairness. The audit must be conducted by experts in data science, ethics and social policy with no tie to the DWP or system developers. True independence is key. The audit would be able to look at issues such as accuracy, are the algorithms correctly identifying overpayments? Fairness, do they unfairly target certain groups and operate with bias? And above all, transparency and accountability. So after each audit, we suggest that a full report must be published, presented to Parliament within 14 days and made publicly accessible. If serious flaws are found, the Secretary of State must respond within 30 days with a clear action plan to fix these issues. Liberal Democrats overall are positive about benefiting from new technology, but we do need to consider whether it is offering help, not harm. And if we look at the wider context, what work is the use of AI generating? There are already chronic staff shortages at the DWP, with 20% vacancy rates becoming routine. Disability Rights UK have commented, operational failures now permeate every layer of welfare administration. So the situation is that fraud investigation teams already lack capacity to address the 6.4 billion in annual overpayments. There are only 4 fraud advisors per regional office to handle cases flagged by frontline staff. And that has created a bottleneck where very often 90% of suspected fraud cases go uninvestigated. In other words, one could suggest that there is plenty of fraud already to investigate without trawling for more. So, new clause 11, this amendment ensures regular scrutiny, transparency and fairness, and I urge the Minister to consider it. Thank you.
Minister.
Thank you, Chair. And I think it's important at this point that I begin by paying tribute to the millions of unpaid carers across this country. This government recognises and values the vital contribution made by carers every day in providing significant care and continuity of support to family and friends, including pensioners and those with disabilities. The 2021 census indicates that around 5 million people in England and Wales may be undertaking some unpaid care, with many of us taking on a caring role at some point in our lives. Like other honourable members, I see much of the work carers do through my postbag and also at events I attend across my constituency. Carers are fortunate enough to have some wonderful advocates, including their MPs, of course, but also organisations such as Carers UK, the Carers Trust and the Learning and Work Institute, to name but 3. We inherited a system where busy carers, already struggling under a huge weight of responsibility, have been left having to repay large sums of overpaid carers allowance, sometimes worth thousands of pounds. We needed to understand exactly what has gone wrong so we can set out our plan to put things right. That is why we launched an independent review of earnings-related overpayments of carers allowance. We were delighted that Liz Sayce, OBE, agreed to lead this review. The independent review is now well underway and it is anticipated it will arrive at its conclusions this summer. The review will investigate how overpayments of carers allowance have occurred, what can best be done to support those who have accrued them, and how to reduce the risk of these problems occurring in future. But we are not sitting back and just waiting for the outcome of the independent review. Right now, we want to make it as easy as possible for carers to tell us when something has changed in their life which could affect their carers allowance. So we will continue to review and improve communications. And from this April, the weekly carers allowance earnings limit will be pegged to 16 hours work at national living wage levels, and in future it will increase when the national living wage increases. The earnings limit will be £196 a week net earnings compared to £151 today. Over 60,000 additional people will be able to receive carers allowance between 2025-26 and 2029-30 as a result. This is the largest ever increase in the earnings limit since carers allowance was introduced in 1976. As the Chancellor said at the budget, we need to look at the current cliff edge earnings rules. A taper, for example, could further incentivise unpaid carers to do some work. It could also reduce the risk of significant overpayments. However, introducing a taper in carers allowance is not without challenges and could significantly complicate the benefit as it currently stands and would mean a significant rebuild of the carers allowance system. DWP has begun some scoping work to see whether an earnings taper might be a feasible option in the longer term, but any taper will be several years away. Turning specifically to the amendment that is new clause 10, there are 4 points to this new clause. As I have already mentioned, an independent review has been commissioned, its terms of reference have been published and it is well underway. It is anticipated that it will report its conclusions in the summer. Both from the report from the independent review and the government's response will be published, and we will report to the House. But there are two issues on which I disagree with the Honourable Member. It would not be responsible for us to commit in advance to implementing all and any recommendations for a review such as this without having seen them. We would need to carefully consider them first, and I need to point out that this amendment would not have, as I understand it, the effect he desires. We would still be able to recover overpayments of carers allowance as we do now from benefits under the powers in the Social Security Administration Act 1992. What this amendment would do is prevent us from recovering debt directly from the bank accounts of those not on benefits or on PAYE, which is one of the additional powers in this bill. But even as the amendment was intended, it would be disproportionate to suspend all recovery of carers allowance overpayments until after the review is concluded, as those with overpayments are already covered by the usual safeguards of appeal rights, affordable deductions and, in exceptional circumstances, waiver. Given the discrepancy this would create between those on PAYE and benefits and those with other forms of income, I would hope that the Honourable Gentleman would acknowledge the need to withdraw this amendment rather than create a further unfairness in the system. Turning now to the proposed new clause 11. Firstly, I'd like to re-emphasise that while we wait for the conclusions of the independent review, we will not speculate on the findings or review any potential outcomes. All recommendations will be considered when the independent review concludes. It would not be appropriate for the Department to commit to this new auditing requirement until this has happened, and we can take a holistic view of carers allowance and how DWP uses data. Nevertheless, I believe it is helpful to set out how DWP currently uses data to verify eligibility for carers allowance. Verification of earnings and pension, or VEP alerts, were introduced to carers allowance in October 2018 as part of a wider strategy to identify data sources to verify information provided by the claimant or identify if information hasn't been provided by the claimant. Like all data we use for this, it is not intended to replace the legal requirement of a claimant to provide information that may change their entitlement to Social Security. VEPS alerts are from HMRC payroll data. The alert service provides a notification of new earnings or pensions as they come into payment, or if amounts change during the life of the claim. The Department uses business rules to prioritise these alerts based on data provided by the real-time earnings system. Since 2019, we've actioned around 50% of the alerts received through the Department. It is part of our focus on helping to reduce the risk and level of overpayments. Following securing additional funding in the one-year spending review, we will be deploying additional resource in 2025-26 to action the alerts received from HMRC as quickly as possible. The Department is also testing an approach of using text messages to remind customers of the need to report changes in their circumstances. Finally, I want to emphasise that the use of VEP alerts does not replace human decision-making. If the Department processes an alert that highlights that there has been a change in earnings and a customer has not reported these changes, DWP officials will contact the customer to confirm details of the change. If any overpayment is identified, it will be referred to debt recovery teams. DWP remains committed to working with anyone who is struggling with their repayment terms and will always look to negotiate sustainable and affordable repayment plans. In light of the information that I've set out and the ongoing work of the Carers Allowance Independent Review, I therefore urge the Honourable Member to withdraw his amendment. I was then going to speak to Amendment 32, but as it's not yet been moved, I will wait.
Rebecca Smith.
Thank you, Chair. I will speak to new clause 10 and 11 as well, and not Amendment 32 at this stage. Liberal Democrat new clause 10 would delay any payments being taken from people who the government may think owe repayments on carers allowance until the independent review into carers allowance overpayments has been published and fully implemented. Liberal Democrat new clause 11 would provide for an audit of algorithmic systems used in relation to carers allowance overpayments. It would require that if any audit identifies significant inaccuracies, unfairness or biases in any algorithmic systems, then the Secretary of State must, within 30 days of the publication of the report outlining these findings, present an action plan to Parliament which outlines the steps which the government intends to take to discuss the identified issues. Now, I'm interested to know why the Liberal Democrats are singling out carers allowance for this treatment, namely the review of the algorithmic systems, rather than any other allowances or benefits. Is there a reason for this? And in terms of Amendment 32, do I speak to that now anyway? Perfect. Liberal Democrat Amendment 32 is a commencement block. It specifies that no part of this Act may come into force until the recommendations of a report commissioned under section Recovery of Overpayments of Carers Allowance have been implemented. We would suggest that there is a more holistic information that should be made public before the Act can be commenced, and that the focus on carers allowance is in danger of missing the bigger picture. For example, we need to see the codes of practice. We need to know precisely how the banks will deliver their responsibilities under the Act, and I would suggest that these things, which sadly are not yet available for the House as we scrutinise the legislation, which has greatly hindered us, would provide a much more holistic assessment of whether the government is ready to implement the Act than the report on recovering overpayments of carers allowance. So would the Liberal Democrats consider an amendment at a later stage that goes wider than this? Thank you.
Minister, and on Amendment 32.
Thank you, Chair. So on Amendment 32, I would contend that, again, this is simply disproportionate, given the wide range of benefits that this bill is expected to deliver to address fraud and error, not just in the social security system, but in the public sector more widely. It is essential that all of government has access to the capabilities and tools required to stop fraudsters stealing from the taxpayer. Tens of billions of pounds are being lost to public sector fraud. These losses are unacceptable and waste enormous sums of public money which could be put to good use. Delaying this Act coming into force will risk £1.5 billion of savings over the next 5 years. These have been certified by the OBR. This government made a manifesto commitment that it will safeguard taxpayers' money and not tolerate fraud or waste anywhere in public services. This bill delivers on this commitment, and delaying its delivery is unfair on taxpayers who deserve to have confidence that money spent by government is reaching those who need it and not those who exploit the system. Secondly, and we have already discussed this point at length, I would remind members that this bill introduces new and important safeguards, including provisions for independent oversight and reporting mechanisms to ensure the proportionate and effective use of the powers. New codes of practice will be consulted on and published to govern how new measures will be exercised in more detail. This will include details of further protections. There will be new rights of review and appeal in both parts of the bill to ensure there are opportunities to challenge the government's approach. A human being will always be involved in decisions about further investigation or the recovery of any debt. And finally, I would also return to the point that I made to the committee when we began debating Part 2 of the bill. Data and information sharing are crucial when we look at fraud and error. For example, the eligibility verification measure, whilst it will not be applied to carers allowance itself, will improve DWP's access to important data to help verify entitlements, ensure payments are correct and prevent the build-up of overpayments. This will enable DWP to be tough on those who cheat the benefit system and will be fair to claimants who make genuine mistakes. It is vital that DWP is equipped with the right tools, and delaying this bill will only delay these benefits. So in light of this, I would hope that the committee will resist this amendment.
Steve Darling.
Thank you. I'm happy to withdraw clause 10. Thank you.
Does anyone object to new clause 10 being withdrawn? Then new clause 10 is withdrawn. We now come to new clause 11, which has already been debated. Does Steve Darling wish to move new clause 11?
Happy to withdraw 11.
Okay. Then we now come on to new clause 12. The question: does Steve Darling wish to move new clause 12?
I thought this has already been debated. Am I getting confused, Chair?
It's whether you wish to put it to a vote.
No, I'm happy to withdraw it. Thank you.
Okay. So new clauses 11 and 12 are withdrawn. We now come to new clause 13. I call on Rebecca Smith to move new clause 13.
Thank you, Chair. Our new clause 13 would provide that where someone has been found guilty of fraud or conspiracy to defraud and not made the required payments, the Secretary of State can apply for a liability order. Our new clause further provides that where a liability order has been made against a person, the Secretary of State may use the procedure in Schedule 12 to the Tribunals, Courts and Enforcement Act 2007, Taking Control of Goods, to recover the amount in respect of which the order was made to the extent that it remains unpaid. This new clause is intended to give the DWP powers to apply to the courts to seize assets where fraud is probable with the same burden of proof as for cash seizures. This amendment brings DWP in line with the Child Maintenance Service. I know we've had some debate around this in the past, so this is probably more of a probing or a tidying up amendment than anything else, but it's just useful to get it kind of explicitly said. So it goes without saying that if the Minister is not intending on supporting this, I would be interested to know why. Because if the DWP is serious about recovering money lost to fraud and the person liable is not making the required repayments, then why should the DWP not be able to apply to seize their assets? Thank you, Mr. Weston.
Liability orders.
The question is that new clause 13 be read a second time. Minister.
Thank you, Chair. And similarly to the last amendment we discussed, this is an area where we have a lot of sympathy with the points set out that we want to ensure that we recover money, whether it's fraud against the public sector more widely or fraud against DWP. But we believe this is already covered within the bill, and I'll run through why. Clause 16 provides for the purpose of the amendment, clarifying that the PSFA is able to seek alternative civil recovery through the civil courts in addition to the direct deduction orders and deduction from earnings orders in the bill. It confirms that the PSFA will be able to apply to the county court for a recovery order. This is an order providing that the payable amount is recoverable under sections 85 of the County Courts Act 1984 or otherwise as if it were payable under an order of the court. To note, and in line with requirements outlined in Amendment New Clause 13, Section 85 of the County Courts Act 1984 also refers to the use of the procedure in Schedule 12 to the Tribunals, Courts and Enforcement Act 2007 to recover the money. This will enable PSFA to seek enforcement of a debt by applying for a warrant of control in the county court, enabling a court enforcement officer to seize and sell goods to satisfy the debt. This ensures that the PSFA is able to pursue recovery through the most appropriate and effective mechanisms. Amendment New Clause 13 is therefore already provided through this bill for the PSFA and through existing legislation for DWP. Section 71 and Section 71ZE of the Social Security Administration Act 1992 to be specific, allowing them operational flexibility to recover money in the most effective and efficient way to return money to the public purse. It does not require an amendment to do this.
Rebecca Smith.
Thank you, Chair, and by leave I'll withdraw new clause 13.
Does anyone object to new clause 13 being withdrawn? The new clause 13 is withdrawn. We now come to new clause 14. I call Steve Darling to move new clause 14.
I would like to pass on to my colleague for Horsham, Chair. Thank you.
Thank you, Mr. Chairman. New clause 14 would require that the use of algorithms, algorithmic tools and systems and artificial intelligence, including machine learning, should be included within the algorithmic transparency reporting standard. This is a standard established by the government which is supposed to be mandatory for all government departments. However, The Guardian last November reported that not a single Whitehall department has registered the use of AI systems since it was made mandatory. Throughout this debate, the government has consistently downplayed the risk of using AI to trawl for suspect claimants. But if it really is that simple, then why have so many organisations come out with concerns and opposition? That includes Age UK, ATT Fourth World, Amnesty International, Campaign for Disability Justice, Child Action Poverty Group, Defend Me Digital Me, Difference North East. I could go on. I have half a page, which I will spare the committee, of a list of organisations who have expressed their concern. It's quite a roll call. Governments can and indeed will get things wrong if history tells us anything. In June 2024, a Guardian investigation revealed that a DWP algorithm wrongly flagged 200,000 people for possible fraud and error. They found that 2/3 of housing benefit claims marked as high risk in the previous 3 years were legitimate, in fact. As a result, thousands of UK households every month had their housing benefit claims wrongly investigated. And overall, about 4.4 million was wasted on officials carrying out checks that did not save any money. We know that more mistakes will happen no matter how hard we try to avoid them. So I therefore ask the Minister to support the insertion of new clause 14 as a small measure of defence against future institutional failings. Thank you.
Inclusion of systems within the algorithmic transparency reporting standard.
The question is that new clause 14 be read a second time. Rebecca Smith.
Thank you, Chair. Just very briefly, as we've heard, the Liberal Democrat new clause 14 requires the use of algorithms, algorithmic tools and systems and artificial intelligence, including machine learning, to be included within the algorithmic transparency transporting standard. Now, I've obviously just heard the honourable members from Horsham's comments, but I would be interested to know precisely what the Liberal Democrats are aiming to achieve with this amendment and how such reporting would better enable the government to crack down on fraud and error, and is this the intention of the amendment? If so, that's all I'd like to ask. Thank you.
Minister.
Thank you, Chair. On new clause 14, I do share the honourable member's support for the algorithmic transparency recording standard as a framework for capturing information about algorithmic tools, including AI systems, and ensuring that public sector bodies openly publish information about the algorithmic tools used in decision-making processes that affect members of the public. However, I do not think that this new clause is a necessary addition to the bill. Firstly, all central government departments, including DWP and the Cabinet Office, are already required to comply with the standard as appropriate. We're committed to ensuring that there is appropriate public scrutiny of algorithmic tools that have a significant influence on a decision-making process with public effect or which directly interact with the public. We have and will continue to follow the guidance published by the Department for Science, Innovation and Technology on this to ensure the necessary transparency and scrutiny. Secondly, I remind the committee that whilst DWP and PSFA are improving their access to relevant data through this bill, we are not introducing any new use of machine learning or automated decision-making in the bill measures. I can continue to assure the House that, as is the case now, the human will always be involved in decisions that affect benefit entitlement. Thirdly, whilst I don't wish to labour the point yet again, I remind the committee that the bill introduces new and important safeguards, including reporting mechanisms and independent oversight on the face of the bill, demonstrating our commitment to transparency and ensuring that powers will be used proportionately and effectively. DWP takes data protection very seriously and will always comply with data protection law. Any information obtained will be kept confidential and secure in line with GDPR. It is for these reasons that I resist the inclusion of new clause 14.
John Milne.
Thank you, Mr. Chairman, and I'm content to withdraw the amendment.
Does anyone object to new clause 14 being withdrawn? In which case new clause 14 is withdrawn. We now come to new clause 15, which has already been debated. Would Rebecca Smith wish to move new clause 15 formally?
I would like to move it formally, please, Chair.
The question,
Sense of encouraging or assisting others to commit fraud.
the question is that new clause 15 be read a second time. As many as are of that opinion say aye.
Aye.
Does the contrary no?
No.
Division. Lock the doors.
Joanna Baxter?
No.
Sean Berry? Neil Coyle? No. Steve Darling?
Abstain.
Charlie Dewhurst?
Aye.
Damien Egan?
No.
Jill German?
No.
Georgia Gould?
No.
Sally Jameson?
No.
John Milne?
Abstain.
Michael Payne?
No.
Rebecca Smith?
Aye.
Michelle Welsh? Andrew Weston?
No.
Mike Wood?
Aye.
The ayes were 3, the noes were 10. The noes have it, the noes have it. We now come to new clause 16. I call Rebecca Smith to move new clause 16.
Thank you, Chair. Our new clause 16 would require the Secretary of State to conduct a review of whistleblowing processes in relation to fraud in the public sector within 1 year of the passing of this Act. We would like to review to include the appropriateness and efficacy of existing whistleblowing processes, barriers to reporting fraud and reasons for underreporting of fraud, and recommendations for change. We've talked previously in this committee about the 2023 National Audit Office report, which highlighted the difficulties with whistleblowing within the public sector, particularly in respect of whistleblowing on senior colleagues. The NAO also highlighted that of the public sector whistleblowing disclosures they received in 2023 to 24, 12% related to fraud. I didn't get a particularly clear answer from the Minister about safeguards that have been put in place to ensure that more junior civil servants are able to raise concerns about more senior members of staff, so I'd be interested to see if there's more to be said. But I do think it is a really serious issue, and one of the reasons why I even have been interested in putting forward this is I actually, as a very junior local authority member of staff, saw this happen for myself, and was in a situation where two colleagues were defrauding the local housing authority, and at that stage as a 21-year-old I didn't feel able to do anything about it, and it's probably one of the biggest regrets in my life. Is probably a bad thing, but having worked in housing significantly since, the fact that I wasn't able to call them out for essentially purchasing a council house that they no longer were living in, I feel that this particular safeguard in terms of ensuring that within the government departments themselves that almost their house is in order as this legislation goes forward is particularly vital. John Smart, who sits on the PSFA's advisory panel, raised the example of the US, which does have whistleblower reward legislation in place, which is very effective at flushing out issues affecting payments made by government. The legislation flushes out frauds by incentivising whistleblowers to blow the whistle, so to speak. He recommended that the government consider this legislation, so could the Minister inform the committee about whether the government has looked into this as an option? Would it be possible for us to learn from this, and could the government consider such legislation in the future, and if not, why not? Thank you, Chair.
Review of whistleblowing processes in relation to public sector fraud.
The question is that new clause 16 be read a second time. Minister.
Thank you, Chair. And I thank the Honourable Member for raising the critical issue of whistleblowing, and I want to give them the assurance of how seriously both Minister Weston, myself and both Secretary of States and our departments take the issue of whistleblowing, and I hope as I set out some of our responses to the NAO report and wider work that will offer the reassurance they're looking for. For internal and external fraud against the public sector, government departments are responsible for their own whistleblowing arrangements and overseeing arrangements in their arm's length bodies. For example, the Department for Business and Trade publishes and regularly updates its guidance, whistleblowing list of prescribed people and bodies, which detail who individuals can raise a concern, which individuals can raise a concern. This list comprises bodies and individuals to whom making a disclosure qualifies the individual making that disclosure to legal protections under the Employment Rights Act 1996, for instance, protecting them from being dismissed by their employer for the disclosure. For public sector fraud, whistleblowers can report concerns where they relate to fraud in the public sector to bodies such as the NAO's Controller and Auditor General, the Director of the Serious Fraud Office, the Auditors General for Wales and Scotland, the NHS Counter Fraud Authority, and various other bodies listed on gov.uk. And the NAO report you referred to set out that between 2019 and 2022, one of the most common concerns was fraud. I think it was 40% of concerns raised. As to the review of existing processes, the recent publication from the NAO, the key findings related to the need to increase awareness of the channels for whistleblowing, improve the experience of whistleblowers and ensure lessons are learned, as the Honourable Member set out. In light of the NAO report and with the intention of opening up as many avenues as possible for the reporting of public sector fraud, the PSFA will explore with the Department of Business and Trade whether it would be appropriate to add the PSFA to the list of prescribed organisations. This would be alongside the existing ability to raise fraud within a public sector body or department. We will also use the findings of the report as well as their good practice guide to whistleblowing in the civil service to inform our own approach. In respect of benefit fraud, DWP has established processes for members of the public and staff to report suspected benefit fraud. Members of the public can report fraud online at gov.uk, by phone or post, whilst DWP staff follow clear internal guidance and processes. Given the intent to maintain the focus of this legislation, the recent work by the National Audit Office, the existing DWP processes and the steps being taken by PSFA to continue to improve the whistleblowing offer for public sector fraud, I will move to resist new clause 16.
Rebecca Smith.
Thank you, Chair, and I appreciate the Minister's response to me in that point. As of today, we will withdraw this amendment, but I would urge the Ministers to just go back and look at what more could be done, because I appreciate the PSFA might come in as a prescribed organisation, but specifically, I'm particularly concerned about how we bridge that gap between more junior civil servants being able to do that whistleblowing against their more senior colleagues, because ultimately that was the kind of deliberate focus of that NAO report. And so I think if there's a way that that can be looked at ahead of the next stage of the bill, I'd be grateful. Thank you.
Does anyone object to new clause 16 being withdrawn? Then new clause 16 is withdrawn. We now come to new clause 17. I call Steve Darling to move new clause 17.
Thank you, Chair. And I'd like to start, Mr. Chair, by acknowledging the hard work that the charity Surviving Economic Abuse have done in this particular area, and thank them for their briefing that I'm sure that they've shared with all members on this bill committee. They are, and we as Liberal Democrats are, very keen to make sure that domestic abuse is on the face of the bill, so that it is something that is taken very serious, particularly around joint accounts where this can play out. Whilst I can almost hear, through you, Chair, the Minister's voice ringing, saying that officers are well trained of the DWP around vulnerable claimants, etc., etc., etc. However, I think getting this on the face of the bill around domestic abuse is extremely important. I know that in my own constituents of Torbay, it is a very wicked issue, domestic abuse, and I'm sad to say that Torbay is not alone in having this as a serious challenge within people's households. So taking this seriously and the government supporting this amendment, I hope will happen. And Chair, we would like to put this to a vote in due course. Thank you.
Duty to consider domestic abuse risk to holders of joint accounts.
The question is that new clause 17 be read a second time. Rebecca Smith.
Thank you, Chair. And in response to the Liberal Democrats' new clause 17, clearly, as Conservatives, as the official opposition, we share their views that tackling domestic abuse and domestic violence across government and using different departments to ensure that we do that effectively is vital. And I believe we've got a really strong track record on ensuring that happens when we were in government in previous years. And in principle, this clause seems like a good idea. I just am conscious that we need to make sure, we need to ensure that the bill doesn't exacerbate and make those who are victims even more at risk and create a problem for them. However, you know, I've done a lot of work around violence against women and girls away from this place, and I'm just conscious of how tricky it can be sometimes to actually be able to prove some of these things, and I'm just wondering whether there might be other ways of achieving the same outcome. And I'm assuming that will probably be a reason why the government are not able to support it. But ultimately, I suppose the question is, there's a lot of language in the amendment around potential and believed to be, and so I suppose my gentle challenge would be, is there a way that this could be worded going forward to other stages of the bill that might make it more achievable and more deliverable, and something that would actually have a place on the face of the bill? As it stands at the moment, I'm not sure that would be the case, but I would be very interested to see this debated further, because ultimately that commitment to domestic abuse and tackling domestic abuse and domestic violence is something that is shared by this end of the opposition bench.
Minister.
Thank you, Chair, and we have reached that stage in committee where the honourable gentleman from Torbay can second guess my comments, so he will be as pleased as I am to know that this is the last of the new clauses for debate, but it is a very serious one. A new clause 17 seeks to place a duty on the Secretary of State to consider the impact of a proposed direct deduction order where a person is a victim of domestic abuse, or officials reasonably believe that person is at risk of domestic abuse and they share an account with a perpetrator of that abuse. I share the view raised by the Honourable Member that where the new recovery powers are exercised, there should be a consideration of whether there is evidence of domestic abuse. However, I do not believe that this amendment reflects the right approach. DWP understands the importance of supporting victims and survivors of domestic abuse and has existing guidance processes and operational best practice for supporting those victims. This amendment would apply to both debtors and non-debtors and does not require DWP to take any steps to identify possible victims. Section 1A of the amendment would place a duty on officials to consider the impact any time a person was a victim, even where DWP did not and could not know that this was the case. And Section 1B implies a duty to assess if there is a reason to believe the person is at risk of domestic abuse, but in many cases, as the Honourable Lady suggested, the DWP will not be in a position to make that assessment. That puts officials in a difficult, if not impossible, position. As these powers will be used as a last resort where multiple attempts to engage with the debtor to arrange a voluntary, affordable and sustainable repayment plan failed, we anticipate we will know very little about the debtor's current circumstances unless DWP has been made aware previously, or there were clear identifiable risk factors. We're working closely with charities, some of whom I know that the Honourable Gentleman will have heard from, to help identify these risks, as I will outline later. Where a joint account holder could be at risk of domestic abuse but is not the debtor, we are unlikely to have ever had direct dealings with them prior to this power being used. So, unless we were directly notified, it is unlikely we would have the information necessary to form that reasonable belief that they were at risk, much less to identify all the cases where the person is currently experiencing that abuse. I do not therefore agree that placing a legal duty on officials in this way is the right approach, but we are committed to continuing to support victims of domestic abuse whenever they interact with the department. This is why we are working with charities such as Surviving Economic Abuse, or SEA, a charity that is dedicated to advocating for women whose partner has controlled their ability to acquire, use and maintain economic resources. SEA are supporting with the drafting of the Code of Practice to ensure robust safeguards are in place and to support and encouraging engagement specifically from those who are vulnerable, including victims of domestic abuse. Whilst SEA work with women, the principles will apply to all victims and survivors of domestic abuse. Frontline debt management staff already receive training for their role, including assessing affordability, discussing hardship and identifying and dealing with vulnerable customers. And as we have already heard, there will be a specialist debt enforcement team who will be exercising the new recovery powers. They will also be governed by a code of practice. As explained, we will be consulting on the draft code of practice, and I welcome further views as part of the wider public consultation. Finally, I note that paragraph 6.1b of Schedule 6 already imposes a broad duty on the Secretary of State to ensure the amount of any deduction is fair in all circumstances, which I consider would include the impact on a victim of domestic abuse, as the Honourable Member seeks in this amendment, where the relevant context and circumstances are known to the Department. So I hope this reassures the Honourable Member that his concerns are addressed in the bill already and that DWP take domestic abuse seriously and will continue to do so when exercising the new recovery powers.
Steve Darling.
Thank you, Chair. I would like to push this to a formal vote. Thank you.
The question is that new clause 17 be read a second time. As many as are of that opinion say aye. Aye. To the contrary, no.
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 Division. Lock the doors.
Joanna Baxter?
No.
Sean Berry? Neil Coyle?
No.
Steve Darling?
Aye.
Charlie Dewhurst?
Aye.
Damien Egan?
No.
Jill German?
No.
Georgia Gould?
No.
Sam Jameson?
No.
John Milne?
Aye.
Michael Payne?
No.
Rebecca Smith?
Aye.
Michelle Welsh? Andrew Weston?
No.
Mike Wood?
Aye.
The ayes were 6, the noes were 9. So the noes have it, the noes have it. Unlock. We now come to the question that clause 99 stand part of the bill, with which it would be convenient to debate clauses 100, 101, 102, 103 and 104. The question is that clause 99 stand part of the bill. Minister.
Thank you, Chair. And this is the final grouping of clauses that the Bill Committee will consider. So I wanted to just quickly say a massive thank you to the Bill Committee for constructive dialogue, which I'm sure will continue. I look forward to a long afternoon and Thursday discussing these final clauses. Turning first to clause 99. This clause covers how this bill will be applied and limited by setting out the retrospective effect of these new powers and make some technical amendments to the Limitation Act 1980. There is a significant policy change in this clause, which is the extension of the existing 6-year limit for civil claims relating to COVID frauds, which I think the committee will agree is critical. Although the application and limitation of this clause covers the whole bill and the powers can be used on existing cases, retrospective effect does not apply for clause 96 and 97, which relate to non-benefit payment administrative penalties. Subsection 3 sets out that the time limit change applies to amounts that an England and Wales public authority is entitled to claim from a person as a result of a fraud which the person carried out. Subsection 5 clarifies what is meant by England and Wales public authority and explains the Scottish and Welsh devolved authorities are not included in this. Subsection 7 makes technical amendments to section 38, subsection 11 of the Limitation Act 1980. Turning now to clause 100, the purpose of this clause is to enable the DWP Secretary of State and the Minister for the Cabinet Office to ensure this bill works alongside all existing legislation. As is usual for bills that may have consequential provision for other acts of Parliament, the power allows the Secretary of State and Minister to amend other legislation to ensure that the bill works effectively with existing acts of Parliament. Clause 101 recognises that this bill requires money resolution, primarily because it confers new functions on the Minister for the Cabinet Office and the Department for Work and Pensions. Turning now to clause 102, this sets out the territorial extent of the bill, whilst Annex A and the accompanying explanatory notes for the bill provides a full breakdown of the territorial extent and application of the bill measures. The provisions in Part 1 apply to England and Wales. Legislative consent is required for Wales for some parts of the Part 1 provisions. The provisions in Part 2 apply to England, Wales and Scotland in relation to reserved matters. As the committee is aware, the UK government does not generally legislate on devolved matters without the consent of the relevant devolved governments. We've written to our counterparts in Scotland and Wales, and engagement remains ongoing with both to seek legislative consent from Wales on the Part 1 provisions that interact with Welsh competence and from Scotland on Part 2 provisions that interact with Scottish competence. Turning now to clause 103, this clause is required to enable the provisions in the bill to be implemented and sets out the way provisions in the bill will be commenced. And finally, clause 104 is very straightforward, confirming the short title of the Act is the Public Authorities Fraud, Error and Recovery Act 2025, to summarise the intent of the bill captured in the long title. Chair, having outlined the main provisions in clauses 99, 100, 101, 102, 103 and 104, I beg to move that they stand part of the bill.
Thank you, Chair. And the good news is that the Minister has answered some of my questions, particularly around Clause 99 and the extension of those retrospective time limits. Clause 100, we know, is a fairly standard Henry VIII power to make consequential provision as a result of this legislation. Does the Minister envisage that that power will be needed to be used very frequently or not? And clauses 101 to 104 are standard provisions, and we do not have any substantive comments to make on those.
I remind the committee we have until 11:25.
Thank you. The Henry VIII powers are just to ensure that that any other legislation is in line with this legislation. We don't expect it to be used in lots of occasions, but we do expect it will be used in some, and welcome the support for the extension to investigate COVID, and thank the committee again for the work on this bill, which will ensure that we take action against fraud wherever it comes.
The question is, of course, 99 stand part of the bill. As many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to the question that Clause 100 stand part of the bill, which has already been debated. With the open committee, I will put the questions that Clause 100, 101 and 102, which have already been debated, stand part of the bill together. The question is that clauses 100 to 102 stand part of the bill. As many of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 23, which has already been debated. Does Rebecca Smith wish to push the amendment to a vote?
No.
The amendment is therefore withdrawn. We now come to the question of Clause 103 stand part of the bill, which has already been debated. With the leave of the committee, I will put the questions that clauses 103 and 104, which has also already been debated, stand part of the bill together. The question is that clauses 103 and 104 stand part of the bill. As many as are of that opinion say aye. Aye. As the contrary, no. I think the ayes have it. The ayes have it. The final question I must put is that I do report the bill as amended to the House. Minister?
Thank you, Chair, and can I place on record my thanks to you and all of the other chairs who have supported us and guided us through the bill. Can I thank clerks and officials from both the Cabinet Office and DWP for their support, my co-pilot, Minister Gould, opposition spokespersons, all members of the committee for their input, and I beg to move the bill to report.
Rebecca Smith? The question is that I do report the bill as amended to the House. As many as are of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. This committee has concluded its work. Well done. Order.